All right.
Further hearing Norris against the government of the United States of America and Canada.
This assumption we will adjourn at 1, but we will give counsel the benefit of an extra quarter of an hour's midday adjournment and resume at 2:15.
Will be very glad of that. The essential point of principle for which I have been contending is that there is no justification for applying any other test than that which emerges from the language and structure of Article 8 itself, under which respect for family and private life is the primary rule and public policy the exception. It would, I submit, be hard to put the point better or more economically than Lord Bingham did at paragraph 12 in E.B. Kosovo, which I showed the court yesterday. The merit of Lord Bingham's formulation in that paragraph is that it describes an approach which is, one, free of a priori assumptions, and two, wholly specific to the facts of the particular case. And there is, in our submission, a world of difference between expecting that most challengers will in fact fail on an even-handed assessment of proportionality and virtually guaranteeing their failure by weighting the scales at the outset. Now, I have no doubt that if proper weight is attached to the public interest in the prevention of crime, most extradition orders will be found to be justified. But on a proper application of the test, the Article 8 rights of the individual will undoubtedly prevail in some cases. Probably it will prevail in more cases than it could ever do under the highly restrictive test applied in successive decisions of the divisional court like Jeso and Tajik. If anything, the divisional court in the present case went further than it had done before by applying a test borrowed from that part of Tajik which was directed to Section 91 of the Act, thus effectively importing a test of injustice or oppression, which is not to be found in Section 87. Now, turning from principle to the facts of the present case, I suggest that one should look first at the weight of the public interest in Mr. Norris's extradition, and secondly, at the countervailing factors affecting the private and family life of both Mr. and Mrs. Norris. Looking first, therefore, at the public interest in proceeding with the extradition, the first point to be made is that cases of obstructing justice vary very much in their seriousness. The facts relied upon by the Department of Justice are set out in the indictment and summarised, I think, fairly in our printed case. The problem is that in the absence of any obligation on the part of the United States to show a prima facie case or even disclose their evidence at this stage, it is difficult for the court to form any view about where on the scale of gravity this case falls. The most that one can say is that the facts alleged in the grand jury indictment raise matters which, apart from any bar under Section 87, ought to be determined.
Can I just be quite clear? Is it tab 13 that is the most up? Yes, 13, the most up-to-date version. It's called the second superseding indictment. Am I right to think that's the one we should?
I believe the answer is yes, but let me just check.
It's dated September 2004.
I can't read that word.
Yeah. That's the second superseding indictment.
Yes, that is so. It's the indictment of September 2004.
You're right, thank you.
Now, clearly, as we've pointed out in our printed case, the allegations against Mr. Norris are very much in dispute, so that all one can say, as I've suggested, is that apart from Section 87, they are clearly grave enough to warrant to need to be decided. Now, what one can perhaps say about their gravity with reasonable confidence is that the obstruction of justice charges were not the main object of the US prosecutor's efforts. The allegation was that Mr. Norris was engaged in covering up his and Morgan Crucible's breaches of US antitrust law. That case of obstruction was essentially parasitical on the allegation of price fixing, an aggravating factor in that allegation. Now, that is presumably why, on Mr. Norris's first appeal to the ultimate Court of Appeal, Lord Bingham, with the concurrence of the rest of the Judicial Committee, described them as subsidiary counts. Having removed the price-fixing charge from the scope of the extradition proceedings, the Judicial Committee then thought that that made enough difference to the balancing exercise to warrant remitting the case to the district judge to carry it out again. Now, in itself, that must suggest that the committee must have thought that an indictment charging obstruction of justice alone was significantly less serious than one in which it was coupled with the principal offence. They must also have considered that it was sufficiently less serious to be capable of producing a different outcome. Now, there are perhaps three discrete points which can be added on this point before I turn to the factors militating against extradition. One is that the acts alleged against Mr. Norris under the counts of obstruction were acts done in England at a time when the relevant English law was a great deal less clear than it would be now. The whole subject of antitrust is an area where, for at least a century before 2002, the British and American legal values had differed. The allegation is that Mr. Norris obstructed a US investigation of price fixing at a time when there was no statutory offence of price fixing in the UK, and nobody has at that stage suggested that it might be an offence of common law. Ultimately, of course, it was held by the House of Lords that it was not an offence. The principle that for extradition purposes, acts, including acts of obstruction, were to be treated as done in the country where they were intended to have their effect, although it was certainly established, was by no means as well understood in 1999 and 2000 as it is now in the aftermath of the House of Lords decision in Armas. Now, the risk in those circumstances that the fear of extradition will be diminished, or that crimes of obstruction, or indeed crimes generally, will be encouraged if the private and family life of Mr. and Mrs. Norris is held to prevail over the public interest in his extradition for this particular offence, is, in our submission, extremely remote. Now, the second discrete point is directed to US sentencing practice. The evidence, essentially that of Judge Martin, is in the bundles, but for my purposes, the finding of the Divisional Court at paragraph 43 of their judgment,
Paragraph
43, is good enough. That was to the effect that there is, as they put it, at least a lively possibility that if Mr. Norris were convicted of obstruction in the United States, the sentencing judge would be entitled to form the view that he had also committed the offence of price fixing and to treat that as an aggravating factor in arriving at the appropriate sentence. Now, before the Divisional Court, there was argument about the implications of that for specialty. I do not have leave to bring that point before this Court, and I am not seeking to do so. What I am, however, entitled to say is that in assessing the proportionality of extraditing Mr. Norris to face trial in the United States for obstruction, one matter which it is fair to take into account is that he would face the prospect there, if convicted, of serving a sentence which, at least in part, reflected conduct for which he had not been extradited.
I wondered about how this actually would work out in practice, Mr. Sumption. I'm looking at tab 22, paragraph 5. This is, I think, Mr. Martin's witness statement that you asked us to look at, and it's a statement he prepared after the House of Lords.
I'm sorry, my lord, I didn't didn't hear.
It was a statement he prepared after the House of Lords had pronounced their
Yes, it was.
judgment, as I understand it.
Yes.
And in paragraph 5, he's saying at the bottom of the page that the US prosecutors intend to invite the court to make findings as to the alleged price-fixing conduct and rely on them in enhancing any sentence. I think there are 2 points there. One is that I would have thought it was inevitable, if you're dealing with a case about obstructing justice, to have before the court some material about what the basic point in the case was.
Indeed.
Otherwise it's detached from its reality. So that part I would have thought was not objectionable.
Yes.
It's the question about the sentencing practice. Is
Yes.
it that you're...
I am not objecting to, I'm certainly not objecting to the notion that US law enables the court to take into account matters of which the defendant was not convicted. That would not be permissible in the United Kingdom, but it manifestly is permissible in the United States. At one stage, I objected to it on the specialty grounds that the Home Secretary could not properly be satisfied that specialty arrangements were in place to ensure that Mr. Norris was not dealt with for an offence other than that for which he had been extradited because of this practice.
Yes.
That was a matter which I accepted was not something that the divisional court could decide in my favour, because there were two fully reasoned decisions of the divisional court saying that it did not amount to dealing with for the purpose of the statute. On the other hand, while I petitioned for leave to bring that point before this court, my petition was not successful in that respect. At present, I am deploying the point for a completely different purpose, namely for proportionality, namely that if Mr. Norris were to be convicted, the evidence is that, to use the divisional court's own phrase, there is a lively possibility that he would actually have to serve a sentence which was longer by virtue of the possibility that the judge would conclude that he had also engaged in price fixing. As my Lord Hope points out, it's very difficult to put forward evidence of obstruction without needing evidence of that which one is endeavouring to obstruct. So that
But that doesn't follow from that you are guilty of that which you are endeavouring to obstruct. You might be trying to obstruct somebody else's
No, it doesn't.
trial.
But there would clearly be some material there of the obstruction which would entitle a judge, if he considered that the evidence justified a conclusion that Mr. Norris was also guilty of price fixing, and taking that into account as an aggravated
Is that
factor.
what is being said here? Because it seems to me there's an ambiguity as to the manner in which the conduct would weigh in the scales on sentencing. I thought there was evidence that in the United States you cannot sentence somebody for an offence for which they haven't been indicted, or particulars which at least
there is a decision
not clear.
of the Supreme Court which was a relatively recent one, which led to the indictment being reformulated and the formulation of a superseding indictment, or a number of editions of the indictment. And that decision was to the effect that facts relevant to the sentence have to be alleged in the indictment. Now, the fact is that you can allege the offence in the indictment, but as I understand the American procedure, it would be open to them to lead evidence contained in the indictment, but going purely to matters relevant to sentencing on counts 2 to 4, without actually proceeding with an attempt to have Mr. Norris convicted on count 1. That I understand to be how it would work. So they would have to produce evidence, but it would not be difficult for them to justify producing evidence, one, as part of the background of facts alleged by them in relation to counts 2 to 4, and two, as being relevant to sentencing.
But the classic formulation of the specialty rule is that you shouldn't be tried or sentenced for acts which are not extraditable.
Well, the statutory formula is that you shouldn't be dealt with for those acts,
Yes.
Which is a little less specific than your Lordship's summary. I mean,
Well, I'm taking it from things like the Harvard draft on extradition.
Well,
the classic international law.
yes,
Sense.
there are many arguments which, if I had leave, I would be running, and your lordship has mentioned one of them, but I don't.
But my point really was based on prosecution practice, and I'm speaking against the background of Scottish practice, where charges are put forward in a narrative form.
Yes.
And if I was drafting an indictment there, I would have found it quite difficult to avoid mentioning what the nature of the creature was in the United States, which you were attempting to obstruct.
Indeed.
Now, it's not that you were seeking a conviction for that, but just simply background information which would have to be established as fact in order to understand there was some course of justice which should be obstructed.
Indeed.
That's all. It doesn't necessarily mean that you're being sentenced for it, but you're simply putting the facts out so that you understand the nature of the obstruction and the gravity of the obstruction.
That is so. And in fact, narrative indictments are also the practice in the United States, as you will have seen from the indictment here, and from the cross-references from one count to another. But the point in this case goes beyond simply deploying the underlying price fixing as part of the background to the allegations of obstruction.
On your assumption, we've looked at paragraph 43 of the Divisional Court judgment, where they speak of a lively possibility the sentencing judge will have regard for the price-fixing allegations. But they set out their thinking, surely rather more fully, at paragraph 54, don't they? Well, I say they, Lord Justice Lord, with whom Justice Openshaw agreed.
Yes. Well, nothing that I say is intended to disagree with anything in paragraph 54. 43 simply sets out the relevant finding of fact based on evidence which has been summarized in the preceding paragraphs. 54 makes the point that you are still only being sentenced for the charge of obstruction, notwithstanding that the sentence may be longer because the judge thinks that you have also committed a related offence.
How can it work? I can understand a penumbra of surrounding facts, including the allegation that you've committed, presumably a contemporary suspicion, at least in the mind of the person seeking to cover up what's happened, because otherwise he wouldn't be covering it up.
Yes.
But to proceed on the basis that you just mentioned, namely that he's actually committed the price-fixing offence, is presumably to proceed on a basis which Mr. Norris wouldn't accept and which could only be tried, normally decided by a full trial.
Yeah, well, no, but the problem about this is that the matters relevant to sentencing are matters which, subject to limited exceptions, are for the judge to determine.
Well, so he would conduct what we would call a sort of voir dire hearing. He'd decide for himself.
In practice, as I understand it, he would not. What he would do is he would rely on such inferences as he was in a position to draw from the evidence that had been led in the course of the trial. Now, this is a process which I accept is strange to English legal ears and would be completely out of the question in a sentencing process in England. But in that is one respect in which the position appears to be different in the United States.
Insofar as Mr. Norris gets a chance to answer the allegations, it has to be sort of by the by during the course of the trial.
Well, indeed. And I mean, this isn't a problem that has arisen simply in this case. There have been two other cases, Thrasher and Birmingham, in which this particular feature of US sentencing practice has been at the heart of the case before the divisional court. And in both of those cases, the question arose whether that state of affairs constituted being dealt with for anything other than what you were extradited for. And those cases went against the extraditee, which was the reason why, subject to appeal to this court, for which I didn't obtain leave, I conceded the point in the divisional court.
One can see, just to put a very precise context on this discussion, in tab 13, pages 8 and 9, the narrative of the overt acts which the prosecutor is seeking to prove. And it's time and time again you see reference to price-fixing agreement,
yes.
price-fixing meeting, and so on and so forth. And it's all sort of, the web of it is all intertwined with the price-fixing thing. And I find it very difficult to see how it would be impossible for the prosecution to proceed without introducing that amount of evidence.
I respectfully agree.
And it having then been in the evidence as part of what this so-called obstruction to justice was all about,
yes.
How he could put it out of his mind when he's sentencing.
Well, in England, it would be the obligation of the judge to impose a sentence only for the obstruction. It is, after all, possible to obstruct, I think one of your lordships pointed out, to obstruct the investigation of an offence without being guilty of the principal offence. And the judge in England would be bound to sentence him for the obstruction charge, if he had not been charged with the principal offence, on the assumption that he was not guilty of the principal offence. But that is not the position, it seems, in the United States.
Count 1 would surely have to be struck out.
I don't think it has to be struck out. I think what has to happen is that the Home Secretary has to seek assurances from the United States that he will not be dealt with in respect of that count. And in the manner in which the expression dealt with has been construed in Birmingham and Thresher, and indeed in this case, though only on an issue of leave, that would be perfectly consistent with their producing evidence which would also have been relevant to count 1. In other words, the obligation of the United States would be not to seek a verdict against Mr. Norris on count 1.
The Secretary of State refused to make representations.
The Secretary of State, I'm sorry.
Refused to make representations.
Well, the Secretary of State was satisfied with the assurances that the United States gave him that he would not they would not seek a verdict against him on count 1, and on the view taken by the Divisional Court in Thresher and Birmingham, the Secretary of State was entitled to do that. The essential summary of what Judge Martin says about this is at paragraph 10 in the witness statement at flag 22, a finding made by the judge on the balance of probabilities that a person convicted of obstruction was also guilty of the underlying offence.
Sorry, paragraph 10.
Paragraph 10, page 414, behind flag 22.
Yeah.
This is the conclusion from the material that's been marshalled before. That a person convicted of obstruction was also guilty of the underlying offence could, depending on the seriousness of the underlying offence, have a very significant impact on the overall sentence imposed.
It must be possible to craft a suitable undertaking from the United States prosecutor to ensure that there is no risk of his being dealt with in the proper sense for the offence which was not an offence under UK law.
By the proper sense, do you mean the sense in which I would have submitted had I got leave? Your Lordship sees my difficulty.
Well,
and the Home Secretary's difficulty. The Home Secretary can't properly insist on an undertaking which goes beyond that which is required as part of the law of specialty, as declared by the Divisional Court, unless those cases are overruled, which they can't be on this appeal.
So what does this point go to?
It simply goes to the question of proportionality.
I mean, it adds to the weight
Yes.
of what he's risking.
It means that, but after all, the double criminality rule reflects a very significant policy issue for virtually all countries that extradite people to other jurisdictions. What this means is that although extradited only on the obstruction count, the peril to him will reflect also, or may well reflect also, matters on which he will not have been extradited and which English policy would regard as being inappropriate. He wouldn't have been extradited for those charges, because they were not criminal in England at the relevant time. So that simply looking at the scale of the consequences, this is a factor that increases the gravity of the consequences for Mr. Norris, without representing anything for which an English court would say he ought to be dealt with. Now, the third of the discrete factors is both short and perhaps self-evident. It's common ground that we are dealing here with the family life of Sheila Norris as well as Ian. There is no suggestion that she was involved in any of the matters of which her husband is accused, and as regards her personal position, the gravity of what is alleged against her husband is of course completely irrelevant. Now, I don't deny that there are public interest considerations favouring Mr. Norris's extradition to the United States. I will come to the countervailing ones in a moment. But by the standard of the offences which have given rise to extradition and deportation orders, Mr. Norris's alleged offences are clearly at the lower end of the scale. Mr. Norris is not a professional criminal. He's never been in trouble with the law before. He is not in the same class of criminal, even on the allegations of the Department of Justice, as the armed robbers, arms smugglers, professional burglars, and the like, whose careers we have seen traced in the Article 8 case law, many of whom, of course, succeeded in their Article 8 challenges. Now, I want to turn, if I may, from there to
I mean, isn't one fundamental difference between them that they've all been punished and he hasn't? I mean, that's...
Well, one might equally say they have been convicted.
Exactly.
Yes, but
they've been tried. They have...
Yes.
The legal criminal process against them is completed. All that's left in their case is yes or no, having regard to their connection, many of them from close to birth in the removing state, should they, on top of their punishment, also be banished?
Well, the point that I was seeking to make was that notwithstanding that they have been convicted and were therefore in the eyes of the law unquestionably guilty of these offences, many of which were very serious offences, some of their Article 8 defences have succeeded. Mr. Belgesem was a very serious criminal. Mr. Belgidi was a serious criminal. And there are clearly analogies with other cases which have come before the Court of Human Rights dealing with criminal deportation, in spite of the unquestionable fact that they were guilty, something which has yet to be determined and is very strongly denied by Mr. Norris. Nevertheless, they were held entitled to raise Article 8 defences. Now, I want to turn, if I may, from the public interest factors which can be marshalled in support of the extradition to the factors militating against it. And the bare facts, if I may summarise those which appear to be relevant, are these. Ian Norris retired from Morgan Crucible at the age of 59 in 2002. He's now 66 and his wife is 65. They have been together for 50 years and married for 43 of them, with 2 sons and 3 grandsons. Now, next year. Ian Norris suffers from prostate cancer, which is currently in remission. He also suffers from a number of distressing health problems, which I'm not going to discuss in detail in open court, but is recorded in the medical evidence. He has undergone surgery on 3 occasions in the past 8 years for various problems. What the medical reports show is a moderately serious decline in his physical health over the past years. The psychiatric position as regards Ian Norris is that the reports show that he has in fact stood up relatively well to the strains of prolonged extradition proceedings. There has, however, been a marked deterioration over the period covered by the reports. He does not suffer from a depressive illness, but the prognosis is that his extradition and detention in the United States would lead to more significant depressive symptoms. Now, the gravity of those symptoms would, of course, depend on the time frame, but the likelihood must be that he would be 67 by the time of any extradition. He turns 67 in February next, at least 68 by the time of any trial, and if convicted would be sentenced to something between 21 and 27 months in prison. He would therefore be at least 70 when he returned to England.
But that figure includes conduct relating to the antitrust?
No, that figure is simply calculated from the mechanical scale of sentences in the Federal Sentencing Rule Book. And Judge Martin explains how it's done. Now, turning to Sheila Norris, her psychiatric condition gives rise to really quite serious concern. She has been diagnosed as suffering from a major depression of moderate severity, which has resulted largely, if not entirely, from the extended proceedings for her husband's extradition. Now, the prognosis in her case is that her condition would be seriously aggravated if he were in fact to be extradited. It was, as the court will have seen in the evidence, originally Mrs. Norris's intention to accompany her husband to the United States. And she has explained in her second witness statement at paragraph 8 why this is no longer possible. Essentially, the deterioration over the past few years in her psychiatric condition and the fact that she would be on her own in the United States without the support of either friends or children. Now, the facts about the health of Mr. Norris would not in themselves bar his extradition. They do not meet the extremely exacting standard required by Section 91, not least because we accept that on the evidence, Mr. Norris would receive adequate treatment for his health problems in a United States prison. The facts about his health, and about hers also, are important primarily for their implications for their family life together if he is extradited, but they are extremely important in that context. And there are perhaps 4 points which I would like to make about the material in the witness statements. First of all, the state of their health, taken together with the length and closeness of their marriage, has clearly made them highly dependent on each other and increasingly dependent on each other. Mr. Norris has not worked since his retirement 7 years ago. He is at home every day, where he receives daily nursing from his wife. For obvious reasons, that involves a bond of mutual dependence that is close, even by the standards of couples who have been married for more than 40 years. Now, there is a substantial possibility, as the court will have seen in the evidence and indeed in the findings, that Mr. Norris would be refused bail. The Department of Justice has certainly not been willing to say that they will agree to bail. But whether he receives bail or not, the impossibility in current circumstances of Sheila Norris accompanying her husband to the United States means that the interruption of their family life will be total for a period of something like 3 years. Now, in the absence, of course, of his family, none of the visiting rights, which would ordinarily be regarded as mitigating the impact of detention before and after trial, would have any practical value in Ian Norris's case. Now, that is the first point that needs to be made about this material. The second is that it is fair to point out that the enforced separation of Ian and Sheila Norris would not be permanent, as it would have been in some of the immigration cases, and that is a relevant factor. However, it is not a particularly reassuring factor in the case of a man in his late 60s with health problems that make his expectation of life extremely uncertain. The impact of extradition on their life together is clearly much more significant, because it will probably deprive them of a significant part of whatever years remain to them. Thirdly, and more generally, I would suggest that every aspect of the situation in which these two people find themselves has got to be judged in the light of their age. They are relatively vulnerable. It is physically and psychologically much more difficult for people of their age to adapt to a personal disaster on this scale than it would be for people in their prime of life, in good health, and with much to look forward to beyond the next 3 years. Fourth, these facts must also, I would suggest to the Court, be judged in the light of the very long period for which these extradition proceedings have been continuing. The plea bargain between the Department of Justice and Morgan Crucible and its senior executives, which protected most of the current management alleged to be involved in the cartel, but left Mr. Norris exposed, was made in 2002, shortly after Mr. Norris's retirement. The witness statement of Sheila Norris describes the devastating impact that the news of that event had on them. Now, the relevant indictment against Ian Norris was returned some 2 years later in September 2004, although there had been earlier indictments in different terms, and he was arrested on a warrant requested by the Department of Justice in January 2005. He has been on bail on stringent conditions governing his residence and movements since then, and that was very nearly 5 years ago. Now, I referred your lordships and my lady yesterday to E.B. Kosovo and to Lord Bingham's observations about delay. In my submission, it is plain from Sheila Norris's witness statements, and indeed from the successive medical and psychiatric reports, that most aspects of their situation have notably deteriorated during that period. The news that the United States was proposing to persist with its attempt to have him extradited after the House of Lords had knocked out what had appeared to be the main stuffing in the case against him was a particularly bitter blow, which Mrs. Norris describes in her second witness statement. The fact is that without the delay, neither of this couple would be in as poor a physical and psychiatric condition as they are. Without the delay, Sheila Norris might have been able to accompany her husband to the United States, as had been her intention at the time of her first witness statement. And without the delay, their mutual dependence would not have increased during this period to the degree that it has. And of course, they were 5 years younger when these proceedings began, and in a somewhat better position to weather the storm. Now, manifestly, I would suggest the delay that has occurred in this case falls within the first of Lord Bingham's 3 categories in E.B. Kosovo, i.e. cases where the importance of the family relationship has intensified during a period of delay. At one point in the story, although I don't wish to overstate the importance of this, namely when the outcome of the appeal to the House of Lords gave rise to hopes that the proceedings would not be pursued for the subsidiary account, it may have been possible for them to draw some comfort as to whether he would be extradited, but I accept that the interval of optimism on that score was a very brief one. Mr. Perry, in his printed case, refers to the delays which, in his phrase, disfigured the pre-2003 system of extradition. Yet those delays were mild in comparison to what has in fact happened in this case. I don't go so far as to submit that the history of these proceedings suggests a dysfunctional system of decision-making of the kind which Lord Bingham had in mind in his third category in E.B. Kosovo. That is, of course, the only head under which it might be relevant whose fault it was. But it is not unfair for me to point out that the length of the proceedings must have been approximately doubled by the prolonged and unsuccessful attempt of the Department of Justice to have Mr. Norris extradited for something that was not an extradition offence, namely price fixing. Now, those are, I would suggest, the essential considerations. Approaching this case with proper regard for the public interest in the efficient operation of the extradition system, but without any limiting preconceptions about the outcome, I submit with respect that it would be an abuse of language to suggest that the extradition of Ian Norris was a proportionate answer to a pressing social need. The highest that the United States have hitherto put their case is that what will suffer is the principle of extraditing accused persons. Now, even if that were the right test, the suggestion seems, with respect, extravagant on the facts. But the problem with the whole argument is that it diverts attention from the particular facts of this case, and it assumes that extradition should in principle be automatic or virtually automatic if there is a compliant request. That simply cannot be so under a statute where extradition is only available subject to the accused's Article 8 rights, and where there is a serious evaluative exercise to be performed under Article 8, which cannot simply be marginalised as a formality. We are not concerned in this case with the relative importance of two general principles. Yet, what is the United States' alternative position? Do they really say that the cause of preventing crime will suffer any substantial setback if someone in the particular position of Mr. Norris is not extradited? And if they do say that, what are the cogent reasons which are normally required in order to satisfy the test of anxious scrutiny which the courts of England traditionally apply in cases where it is sought to justify a prima facie infringement of a convention right? Now, unless there is any other matter that I can deal with, those are my submissions.
Thank you very much, Mr. Chamberlain.
My lord, my lady, Liberty are very conscious that permission to intervene is in the gift of the court, and they don't want to abuse that privilege by repeating any of the submissions made in writing or orally by Mr. Sumption, whose points of principle are those with which the interveners agree. Accordingly, we seek only to make a few simple points on the discrete issue of the mechanism, the decision-making mechanism that should be applied when considering Article 8 in this context. And by seeking to give focus on that ancillary matter of the mechanics, we seek to give emphasis as to why a carefully calibrated approach to the assessment of convention rights is required, and how conversely the application of preset high threshold tests are unhelpful, not just for the reasons of principle outlined by Mr. Sumption, but also for reasons of practicality. My lords, my lady, we're going to make three simple points, and because they're simple, they'll be short, and we won't occupy more than 20 minutes of the court's time. And those 3 points are these. Firstly, in an uncontroversial point of principle, namely that the analysis as to whether or not Article 8 has been infringed requires careful and anxious scrutiny by the decision maker. The second point is a short and simple point, that the identification as to whether or not Article 8 is capable of being engaged at all by the proposed Act, whilst readily satisfied in many extradition cases, should not excuse the decision maker from careful consideration of precisely which aspect or aspects of Article 8.1 are in play. And the third point that we'll seek to make is that the starting point in any test of proportionality must be a full and careful analysis as to how Article 8 is engaged and the full extent of the potential infringement. And it is then, and only then, that the decision maker should consider the factors that may qualify those rights.
Just say that again. The starting point must be a full and careful analysis of how Article 8 is engaged and what?
And the full extent of the potential infringement.
Of the potential infringement.
Yes, my lords, our point would be that the cornerstone of the analysis, that there's a mechanism, and the starting point is Article 8 and the Article 8 rights that are engaged. And it's only then that you need to counterbalance it with the public policy points in Article 8 too.
There isn't a dispute, I didn't think, here that Article 8 was engaged.
No, there isn't, my lord, and I'm not going to deal with the substantive points that we deal with in writing. All that we seek to do by this intervention, because the substantive points that we deal with in writing, and this assumption is dealt with, is make a few points about the decision-making process, because we say by doing so, it may assist the court in the answers, the questions in this appeal. My lord, can I deal with the first point, which, as we say, is a short one, and our point could scarcely be more simple, and we just remind the court of the obvious, that the rights protected by Article 8, whilst capable of qualification, are nevertheless fundamental human rights. Their relevance in the modern world recognised in Wang by Lord Bingham at paragraph 18, that's in divider 14 of the bundles, and as Lord Brown noted recently in Beku Betts in respect to the right for family life, time and time again, Strasbourg recognised its crucial importance. It's also, as well as a fundamental right in our own regional treaty, it's a universally recognised human right, fundamental human right, recognised in the Universal Declaration, in the International Covenant of Civil and Political Rights, but also more widely in the Cairo Declaration, the African Charter, and the American Charter. And this background, which is entirely uncontroversial, informs the methodology that should be applied by the decision maker when considering Article 8 rights, because the fundamental of the nature of rights demands careful scrutiny. My lords, an uncontroversial proposition. But applied to the facts of this case, we say it means, in blunt terms, that there should be no shortcuts, no analytical shortcuts of the type that high thresholds, whether exceptionality or striking unusual facts, teases the decision maker into.
I mean, do you say the same thing would happen if you're sentencing somebody who's just been convicted of rape?
Well, what is clear, we say, my lord, looking at the deportation cases to which Mr. Sumption has taken you in detail, is, and looking at the express terms of the Act, which of course mandate that the decision maker must take into account Article 8, in a context which is that is one of the very few defences available to anybody facing an extradition order, that considerations as to the extent to which Article 8 engages the right to family life and privacy, private life, must be a fundamental part of the decision-making process. It's part of the statutory scheme here.
What's the answer to my question?
Well, my lord, we would say that there may well be a good argument as to why in a sentencing in a sentencing policy consideration should be given to the impact that's going to have on somebody's family life or private life. But that doesn't detract, we say, or add necessarily to the role of Article 8, the central role of Article 8 under the 2003 Act.
If you're right, we have the strange situation that if you're convicted of rape and have a family, you might be sentenced to a lesser sentence than if you have none.
Well, my lord, I don't want to advance it on behalf of the intervener that this is an easy point or one that is capable of resolution. In fact, my point is much narrower, not wanting to avoid the question that my Lord Brown raises. But what one can't escape for in this appeal is the fact that you are directed by statute, the decision maker is directed by statute to consider the convention rights.
I don't think the lack of a reference to convention rights in criminal justice legislation means that you can ignore them.
No, my lord, it doesn't. But my point is actually the converse. But here you are expressly directed to it. And the decision, this must be, we say, a central component for the decision maker. It's unavoidable on the face of the Act, and rightly so.
Well, that may be so, but of course the point is not exactly that. The point is, what does Article 8 require? Yeah. Which is why I asked Mr. Sumption yesterday about whether there was any Strasbourg jurisprudence of the impact of prison sentencing on Article 8. Yes. And he said no. And that is the same point that's being put to you, because if Article 8 considerations could prevail over normal proportionality of sentencing principles, well then there are a great many people who are currently in prison who would not be there at all.
Well, my lord, I don't want to duck the question, and I'm not sure I can better or might not be a very good answer to it. But certainly for the purposes of these submissions, our focus is very much on the fact that you cannot avoid it in a decision as to whether or not to extradite. I'm sorry, I accept that doesn't answer directly the question that's raised, which is a difficult and complicated question. But it's not a question that needs to be answered for the purposes of resolving the issue that's before the court at the moment.
I think you would submit that Article 8 considerations would, under one description or another, play a part if one was dealing with sentencing for an offence like the present alleged offence. I mean, rape is obviously an extreme example. I think this case might look very different if it were a case of attempt to extradite to face a charge of rape.
Well, my lord, we respectfully agree, and it's not unusual in a sentencing situation for a plea in mitigation to be raised that in any event covers many of the grounds that would be covered under an Article 8 challenge in any event. The impact on the family.
Now you're getting closer to it, you see. To what extent are these considerations relevant?
But what about prosecution, which is actually nearer to the case? And what about that? Does Article 8 apply in decision as to whether to prosecute?
Well, my lord, could I just go back one step? A starting point in the analysis may well be, is there anything in a plea in mitigation that touches upon issues of private life or family life that would be impermissible to raise in a plea in mitigation?
Well,
would it be, I'm so sorry, my lord.
Well, I can say a court asks for inquiry reports before proceeding to sentence, and is given a good deal of background information, and I dare say quite a lot of information about family circumstances will pass through the judge's mind.
Yes.
But can I mention, I mean, picking up Lord Rogers' point, that I did actually, in a case which I think is called Ray G, I can't remember the exact name, did actually suggest that Article 8 was relevant to a decision whether or not to prosecute a child under 16, I think he was at the time, for rape,
yes,
or whether it should have been a prosecution for statutory intercourse underage. And I don't think other people agreed with me, but I thought there was an Article 8 point there.
Yes. Might I, my lord, firstly just try and finish my point that I was answering in respect of my Lady Hale, and then deal with the point that you raised and my Lord Roger has raised. My lady, I was making a point in answer to my lady's question that by analogy one can ask on a general plea in mitigation, are there any factors touching upon private life or family life that would be impermissible as a matter of law to raise? And my lords, we would say that there isn't. It might be inappropriate and entirely ineffective in a rape case to pray and aid in mitigation the impact upon the convicted person's family life. It would just be ineffective. And there may well be an analogy with the question of proportionality when considering it under the rubric of Article 8, where there's a very serious offence in respect of the person's being there, in respect of the extradition order. It may be less effective when considering proportionality. I beg your pardon, the Article 8.1 considerations may be less effective and less appropriate, depending on the seriousness of the offence. So in the criminal context, one can have Article 8.1, but normally dressed up by another name in a plea of mitigation. As to prosecutions, my lord, we can see no reason why a public body, such as the Crown Prosecution Service, should not take those considerations into account. And it may very well be that little weight will be given to them where the Crown Prosecutor is dealing with a very serious offence. There can be no reason in principle why the Act would not, the Human Rights Act, would not apply to the prosecutor. It may have very little effect, though, on a day-to-day level. I hope that goes a little closer to answering
But does it have to go through that every time it decides whether to prosecute? That if I prosecute him, he may be sentenced, he's got a child, he's got a wife who's ill, so on. Every time I prosecute, do I have to?
Well, my lord, it might be a moment, it might be a decision that takes seconds.
Well,
but here's a public body.
But do I have to inform myself about his wife, his children?
Well,
do those representing him get public assistance in order to put in a lot of reports, stressing the difficulties before a decision whether or not to prosecute?
Well, my lord, that would be, we would submit, unlikely. And it doesn't. The obligations under the Human Rights Act don't necessarily have to go that far in that context. But whether consideration should be given by the prosecutor in deciding not only what to prosecute, not only whether to prosecute, but what to prosecute, we say it's uncontroversial to say that consideration should be given to the right of the person who are going to be affected. And that doesn't necessarily mean that the whole administration of justice and the prosecution system can be clogged up by unnecessary and lengthy tests. But my lords, to bring it back to this appeal, well, there is no doubt, because Section 87 tells us, there is no doubt that the judge must consider the human rights impact. Can I just come back to the stress that I was making on the mechanics? And we say the mechanics are important because they set the framework through which the decision must be made, and it's a framework that must give emphasis to the importance of those rights. The second point we make is a very small and very discrete point, and it's to do with the decision-making process. My lords, in Rasga, the House of Lords set out a 5-step process for the analysis of Article 8 derived from Strasbourg jurisprudence. It was repeated again in the speech of Lord Bingham in EB and Kosovo. Can I very quickly take you to that? It's at Divider 9, page 182 of the report, at paragraph 7. It's in the speech of Lord Bingham. In Rasgar, the House summarised, in terms to which all members of the committee assented and which are not understood to be controversial, the questions to be asked by an adjudicated hearing and appeal against removal on Article 8 grounds. It is said, and then we'll see the 5 questions, in a case where removal is resisted in reliance on Article 8, these questions are likely to be: 1, will the proposed removal be an interference by a public authority with the exercise of the applicant's right to respect for his private, or as the case may be, family life? 2, if so, will such interference have the consequences of gravity as potentially to engage the operation of Article 8? 3, if so, is such interference in accordance with the law? 4, if so, is such interference necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, the protection of health or morals, or for the protection of the rights and freedoms of others? 5, if so, is such interference proportionate to the legitimate public end sought to be achieved? In practice, the 4th and 5th questions are usually and unobjectively taken together, but as expressed, they reflect the approach of the Strasbourg Court, which is that decisions in this field must, insofar as they may interfere with a right protected by 8.1, be shown to be necessary in a democratic society, that is to say, justified by a pressing social need, and in particular proportionate to the legitimate aim pursued.
Mr. Hammer, help me. I'm puzzled for much too long without really following this concept of being justified by a pressing social need and in particular proportion. I mean, if it is proportionate to the legitimate aim pursued, is there any other respect in which it could fail to be justified by a pressing social need?
I'm so sorry. Do I take my Lord's question to be if it is justified by a pressing social need, is there anything?
No, if it's proportionate to the legitimate aim pursued, what's left of the concept of justification by a pressing social need? Is there anything over and above it being proportionate to a legitimate aim involved in being justified by a pressing social need?
It's all part of the decision-making process that allows you to arrive at a decision whether it's proportionate.
But when it says "and in particular," does that leave over any other consideration in order to be satisfied it's justified by a pressing social need?
Well,
I mean, is that just crystallising what is meant by justified by a pressing social need? I would have thought it probably is. But
certainly that's the only... I'm unable to take my Lord to anything in Strasbourg jurisprudence that takes you much further than that, or adds
well, this is an endlessly repeated formula that I can't remember whether they coined it, but in the usual conventional way, they then regurgitated every case. And I just thought I would finally ask the question whether actually it means anything more than the last phrase.
Well, my Lord, I would like to be able to take something that showed that it was expanded in a certain context, in a certain case, but I'm unable to do that. That is the oft-repeated refrain of the Strasbourg Court, as my Lord has noted time and time again. My Lord, paragraphs 8 to 9 of our printed case, we set out by reference to the jurisprudence, both domestic and Strasbourg, primarily domestic, how in an extradition context, tests 1 to 3 are normally going to be readily satisfied. We do make the point, and it is a self-avowedly small point, that should not, even where it's capable of ready answer, excuse the decision maker from actually identifying which rights are an issue. Because Article 8.1 wraps up, obviously, more than one right. And what is striking, both in the decision of the district judge in this case, and I use this case just as an example to illustrate the point, but both the district judge and the divisional court actually fail to identify in express terms whether they're dealing with private life or family life or both in this case. They, of course, set out the evidence that is capable of engaging both, but simply to talk in terms of Article 8.1. Now, my lords, we don't say, of course, that is a failure that is critical, nor do we say that it is capable of vitiating a conclusion to extradite in a case where everything else has been lawfully reviewed. What we do say is that there is real merit in an analytical approach that starts off carefully from actually identifying what rights are in play.
Which do you say they are?
Family life and private life in this case, my lord.
I know, but which are they involved here?
Both, my lord.
Well, what's the advantage of saying that?
Well, my lord, because it sets in motion strict judicial discipline as to the analysis as to whether or not Article 8 is an answer to extradition. And then we say that, and as I said, it's a self-apparently small point, but the starting point must simply be what Article 8.1 rights are in play.
But presumably you would go on from that to say, and then you have to look at the strength of those particular rights in the particular case.
My lady, that's my third point to which I'm going to turn to now. The natural and obvious starting point of any assessment of proportionality is not the analysis of the necessity of qualification. It is rather a comprehensive analysis as to the extent and breadth as to how Article 8.1 is capable of engagement. Put simply, one cannot properly begin to appreciate whether or not a right should be qualified before one has properly assessed the full extent to which that right has been engaged. And one can draw two themes from this. Firstly, it's about the primacy of the structuring of the proportionality analysis. Wherein
Could you just say that
yes,
again?
it's about primacy. It's the primacy of Article 8.1 in the proportionality analysis. And secondly, it's about the need to ensure that that analysis is a comprehensive analysis. The need for a comprehensive analysis has been stressed repeatedly in the immigration cases. Can I simply give my lords 3 references? Firstly, in Rasgar, which is at Divider 22, and it's stressed at paragraph 20 in the speech of Lord Bingham, directly referring to Rasgar 5, it's question number 5, about the severity and the consequences of the interference will call for careful assessment. Next is in Wang, which is Divider 14. It's Lord Bingham giving the opinion of the Appellate Committee at paragraph 15 about the need for the facts to be explored and summarised with care. And finally, in EV Kosovo at Divider 9, paragraph 9, where Lord Bingham stressed again the importance of careful investigation of the relevant facts. We say the obvious starting point must be a comprehensive analysis as to how the Article 8.1 has been engaged. And the difficulty with any approach that doesn't commence from this point, and particularly an approach that encourages the identification of high thresholds, is the temptation of the decision maker will always be to find a shortcut. So rather than analysing properly how Article 8.1 is in play, it simply tempts the decision maker to a quick review to identify whether or not there are 1 or 2 factors that may take a case out of the ordinary. And this again is demonstrated, and we referred them only by illustration, in the decisions under consideration. The district judge, if I can very briefly take you to it, it's at Divider 5. The sole exposition as to the impact on the family and private life of Mr. Norris by the district judge is contained in paragraph 13 of the judgment of the district judge. And the district judge in this paragraph does no more than simply list the available medical records and reports and give their headline conclusions. There is no analysis of the impact upon family life and private life, the only conclusion being that the judge had no difficulty comprehending how the Norrises found the proceedings extremely stressful.
What about paragraph 16?
Well, that's the balancing exercise, my lord, that's undertaken, in which it's taken the Article 8.1 rights, but there's no assessment.
Well, at least it tells you that he's looking at family life. You were saying earlier that it wasn't clear what part of Article 8 was being assessed, but I take it from little 3, or subparagraph 3 in paragraph 16, that he was regarding this as a family life example, not a private life.
Well, my lord, again, as an intervener, I don't really want to comment on the facts of the particular case, but of course you would have seen, not least from Professor Copeman's report, the impact on mental health, which is undoubtedly a private life right. So both are clearly engaged in this appeal. So there's a reference to family life in parenthesis, in essentially the key paragraph. But what is wholly absent, we say, from the district judge's approach is the detailed type of analysis that is called for when you are considering infringing what is a fundamental human right.
So what critical impact on private life did this district judge overlook plainly by reference to his judgment? Of course he doesn't set it all up, as we see, but I mean, what does he actually overlook?
Well, it is one thing for a judge to, when considering whether Article 8 is engaged, it is one thing for it to be sufficient for a judge to simply have to list out medical reports, and to say in the briefest possible terms, well, this engages family life. What the interveners contend for is that because of the importance of the rights that we are dealing with, best practice should be that the decision maker has to consider it in detail, careful consideration. And it's by careful consideration, and it's only by directing yourself carefully to the ways and the various different ways that Article 8 might be engaged, and the impact, the real impact that it might have upon the individual and their family, that you can properly put yourself at the end of the day in the position to balance those.
But I mean, aren't we to assume that Mr. Sumption, who appeared before the district judge, would have said, now look, this is the impact on private life. I don't know, we still haven't seen his closing memorandum on law, in which apparently he made a number of points to be taken into consideration.
Yes, we've got it.
Oh, we have got
Yes,
it. Very
we've got
good.
it.
Oh, I'm sorry. I see. No, I see.
It only deals with law, and it reflects the fact that the argument on law was much less elaborate.
I see. Thank you very much. No, I'm sorry. I'm very glad you...
I'm comforted by that because I thought it was perhaps your closing memorandum in the submissions to this court. It seemed rather sparse.
No, I'm grateful. I'm grateful. Let me glance, if I may, at it.
It deals with 15.
What?
The district judge deals with this part of the memorandum at paragraph.
Yes, 15. No, certainly. Well, it's paragraph 3, 2, and 3, isn't it, really, of this?
Yes, well, we have no doubt that Mr. Sumption fully and comprehensively dealt with all the points on behalf of his client at both hearings. But that's not our point. Our point is in respect of the judge. And what a judge has to demonstrate has been properly taken into account before that judge considers they're going to qualify a fundamental human right. And our point on the district judge's approach, and I'll turn to the divisional court in a moment, is that what is very difficult to describe as a comprehensive analysis, but rather just simply a listing of those matters that were before the court, rather than any analysis, may well be explained by the fact that all the judge thought he had to do was identify whether or not they were striking and unusual facts. And if that's all you have to do, then it inures against actually having a carefully calibrated approach to the way that Article 8.1 is engaged. As I say, my lords, we simply seek to make rather modest points, but nevertheless structurally we say important points.
I suppose what you're saying is that the district judge shouldn't have spent so much of his judgment dealing with what the law was and should have spent rather more dealing with the facts.
Well, certainly the latter, my lady, more dealing with the facts, more dealing with how Mr. and Mrs. Norris's rights would be infringed by the order. Because it's only by doing that that you can properly carry out the balancing test with Article 8.2. And these submissions are all underpinned on two things. Firstly, the fundamental nature of the right, my point 1, and secondly, highlighting the dangers of shortcuts, of judicial shortcuts. But my lords, there's no doubt that when the matter went to the divisional court fully dealt with the medical evidence and the impact upon Mr. and Mrs. Norris, albeit that it didn't start with a dissection as to which Article 8.1 rights. But what is...
Sorry, I mean, you're not quarrelling with the sufficiency, then, of the divisional court setting this out as they do. It's just... which really is it paragraphs 30 to 37?
Yes, my lord, no, we're not. But the criticism that we do make, or the observation that we do make, is as to the ordering, as to the framework that the divisional court applied. Because what is striking is that that assessment of impact at paragraph 30 and onwards only comes after the court had considered at paragraph 28 and 29 the factors militating in favour of qualification of the Article 8.1 rights. And it ends at paragraph 38 with a test that we say is, with respect, the wrong way around. Whether or not, on the whole case, I do not consider that on proper application of law, as I have sought to describe it in the article.
Sorry, where are you reading?
I'm so sorry, my Lord. It's paragraph 38 of Judgment of Law.
38. All right.
On the whole, I do not consider that on a proper application of the law, as I have sought to describe it, the Article 8 considerations can be said to outweigh the public interest in extradition. Well, my Lords, you say with greatest respect, that gets it the wrong way around. The question is, can the rights be qualified? And that should be reflected in the structure of the judgment that considers first the nature and extent to which the Article 8.1 rights are in play, and then and only then turn to Article 8.2. And of course, at that stage, what comes into play, and again, this is uncontroversial, are the factors not only that militate in favour of Article qualification applying, but those factors not amounting to Article 8.1 grounds, but that militate against in the proportionality test, many of which Mr. Sumption has raised today, and we set out at paragraph 39 of our printed case.
Paragraph what?
39, my Lord, of our printed case. So, my Lord, to conclude, our point, as I have stressed, is a simple one. That the court should forego, for the reasons we set out in writing, the search for bright lines and threshold tests. And what is far more profitable, and what certainly requires, we say, emphasis, is a stress on the structured approach to the assessment as to the circumstances in which fundamental human rights can be qualified. The five-step process in Rasgar is the appropriate emphasis. I beg your pardon. The five-step process should be followed with the emphasis given to the primacy of the human right. It is not said on behalf of the intervener that this in any way undermines the importance of the public interest considerations that are manifestly in play in extradition claims, nor is it said that the proper analytical framework for which we contend will result in different outcomes in many cases. But what the interveners do submit, my lords and my lady, is that a rigorous analysis, free of shortcuts, may, and we would say we need to go no further than may make a difference in some cases. And it's for those reasons that we give the stress to the mechanism that we do. Unless I can assist the court any further, those are my submissions.
Thank you very much.
Please, your lordships and my lady, Lord, may I begin by identifying what we would like the court to decide for the benefit of the administration of justice in extradition proceedings.
Can you do so fortissimo, not so much for our benefit, but for the benefit of those who are, I think, are straining to catch your submissions at the back.
Sorry.
There's nothing to do with the microphone. You've just got to speak up.
Yes, I hope I'll be able to, my lord. But Lord, the first matter that we would like the court to decide for the benefit of the administration of justice in extradition proceedings is that in any extradition case in which Article 8 is engaged, there is a starting point, and the starting point is that the weight to be attached to extradition arrangements when conducting the proportionality exercise is always constant and always heavy. The second point we would...
Not just
Fast,
cause.
please. So there's a weight to be attached to...
Extradition arrangements is always constant and always heavy.
So in the imaginary scale,
Yes.
you've got a very large block
Yes.
sitting on one balance, and you're asking yourself, what can you put
Exactly.
on the other one to heap it up to the point at which it tips over? Is that it?
Exactly, my lord, because the proportionality involves ascribing relative weight to the various competing interests. And if you start off with a heavy public interest on the one side, then to overwhelm it is going to take something very special. And that is what the lower courts have done in these cases. They haven't said we're not conducting a proportionality exercise. They have conducted a proportionality exercise, but they have ascribed the appropriate relative weight to the interests served by extradition on the one hand and the interest militating against extradition on the other. So we say there's no difficulty.
There's no difference between extraditing a thief and a war criminal.
No, my lord, there's
no
not.
difference in the interest.
No, my lord, no. Because the legislation is premised on the basis that extradition is only available in serious cases. Now, I was going to say something in due course about the relative severity of particular charges. Of course, you may want to take that into account, but it's interesting to note that in the legislative scheme, there is no triviality exception. It's a cut-off.
12 months.
12 months,
Yeah.
or 4 months in the case of a conviction case. Normal laws
I'm sorry, I mean, Mr. Perry, I mean, is it really always constant? I mean, sometimes a real factor is that you must stop people having safe havens. So, I mean, that would be highly relevant in a case like Wellington, the American alleged double murderer, who comes to this country. And if we don't extradite him, here he stays, he's got a safe haven. But, I mean, if you're extraditing us here, somebody like Mr. Norris, I mean, you can't really regard his position as, so to speak, gaining a safe haven if you don't extradite him. I mean, he's simply left where he started.
But it is a safe haven.
Well,
If you
but in a
commit
very
offences in
different
this
sense.
jurisdiction...
I mean, he hasn't come to the country.
He doesn't have to. If you commit offences against the United States in this jurisdiction and the United States can't get hold of you, you've created a safe haven. And people will commit offences against the United States in this jurisdiction. And people will go on committing offences against the United States if they think it's a safe haven. And then when does the balance have to shift? Because part of the problem with the argument that's been addressed to your lordships and my lady in this case is that, in fact, we're to tell legal representatives and defendants, we're to engage in a confidence trick. Mr. Extraditee, your Article 8 rights are engaged, and I can't tell you how the court will conduct the balancing exercise because it's an evaluative forensic free-for-all. We can throw everything into the pot, and we can have a great time at City of Westminster Magistrates Court for about 3 days, but I can tell you this, you're most likely going to lose. I can't tell you any more than that, because it's a rare case that will win. Well, that's not a way to conduct an extradition process, and it's a futile use of precious resources because it ignores the proper starting point. And
You are in fact, are you using a different game? Perhaps there's a heavy weight to be attached. That presumably means that Mr. Sumption's clients would have to lift a heavy weight, whereas the analogy so far has been with hurdling. There's got to be a high threshold, and they've got to leap a high threshold. Is it the same idea in a different word?
It's the same idea, because it is about the balancing process that's undertaken. But we do start off by saying that the proportionality, the weight to be attached is constant and heavy, and we don't make any distinction between the severity of cases. The second point that we...
Sorry, before you move on from that, maybe you're coming back to this, Mr. Perry, but would you say that all the factors that are listed in the interveners, paragraph 39, are irrelevant?
My lady, I would, and I'm going to come on to deal with them, because if you let those factors loose into extradition, you rewrite the scheme. And one thing you can't do is rewrite the scheme that Parliament has established. But I will have something to say, because we say that not only do they involve rewriting the scheme, they're contrary to settled authority. The second matter that we would like the court to decide, or invite the court to decide for the benefit of the administration of justice, is that the question of whether a trial is possible in this jurisdiction is completely irrelevant. The reason I mention that is that this is becoming now a familiar refrain in extradition proceedings. Don't send me to the United States. I want to be prosecuted in England and Wales, or Scotland, or Northern Ireland.
I wasn't conscious that this was really being raised as a point by Mr. Sumption.
But Lord, it's been raised by the interveners in their paragraph 39.
Oh, sorry,
it's not raised by the appellant's case. I accept that. But, my Lord, with an eye to the proper administration of justice in the future, I would invite, with respect, the court to deal with it, because it is now being raised. And the way it's being raised is, even though there has been no investigation in this jurisdiction, and even though there is no evidence in this jurisdiction, I would prefer to be tried here, and that is properly to be taken into account when informing the proportionality argument. We submit that suggestion that that's relevant to the proportionality argument should be dispelled once and for all. The third matter that we would...
Sorry, are you going to come back to all of these?
My Lord, yes.
Okay.
Yes. My Lord, I'm just trying to identify...
No, absolutely.
The matters that we say would be of real benefit to legal representatives and extradition practitioners and to district judges. The third matter that we would invite the court to decide is that if the district judge has decided that extradition is not oppressive for the purposes of either Section 82 or Section 91 of the 2003 Act, there should be little or no room left for the operation of Article 8. So we submit that if it's not oppressive, for the purposes of Section 82 and Section 91, it's difficult to see what room there is left for Article 8 to operate so as to operate as a bar. Lord, may I make 5 points in relation to why we take issue with the appellant's arguments, and identify the 5 principal reasons which we submit undermine the arguments. First, we submit that the appellant's arguments take too narrow a view of the public interest in the efficient operation of extradition arrangements. So that's too narrow a view of the public interest.
Of the public
interest, my Lord, in the efficient operation of extradition arrangements, because the appellant puts the case on the basis that it's the prevention of crime in the sense of deterrence, whereas our response is that that is only one aspect of the purpose served by extradition. There are other aspects served by extradition, and they are as follows. First, the public interest in the trial and punishment of offenders, quite apart from any aspect of deterrence, for criminal offending to be identified and for offenders to have the offending brought home to them.
Now, if you put that in, it raises in my mind, going back to the point you made earlier, the question, well, can you achieve that public interest in this country? And, you're saying we put that out of our minds.
Because this is only one aspect, Lord, because this is why extradition, it is more like domestic criminal proceedings, but there is a vital component to it which has been overlooked, we submit, in the appellant's arguments, and that is the public interest in judicial cooperation and cooperation between states. That is absolutely vital.
Well, that was specifically one of Lord Justice Laws's touchstones.
Exactly, my Lord. And there is also the denial of safe havens, the other point that was made by Lord Justice Laws, which in fact derives from the landmark judgment of the Strasbourg court in the Suring case.
But Suring, I mean, really, all right, well, I'm sorry.
Well, but Lord, if your Lordship's going to say, well, in Suring they didn't extradite and he went off to Germany because he could be tried there, that was for particular and specific reasons in relation to an Article 3 complaint. It wasn't anything to do with Article 8 considerations.
No.
But, my Lord, may I just deal with a point that was raised in the course of argument by the President, who asked whether the position would be different if the appellant were a fugitive from justice in the true sense of being a person who'd fled from the United States after conviction, and the appellant accepted that the public interest would in those circumstances be greater. We disagree. We say the public interest is at all times the same, whether you have fled as a person convicted or whether you are an accused person, the public interest is constant. The second point, so that's the public interest point. The second point that we say undermines the appellant's argument is that the appellant submits that the question to be asked in each individual case is how much damage would be done by discharging the particular defendant on the particular facts of the case. We submit that's hopeless. It is, first of all, too narrow. It is, secondly, impossible to apply in practice. And thirdly, it would lead to capricious decision-making. The reason we say that it is too narrow is because it overlooks the overall public interest in extradition. The reason why we say it's
too narrow because what?
It overlooks, my Lord, the true multidimensional nature of the public interest in extradition. The reason why we say it's impossible to apply in practice is how is the question of damage to be assessed and evaluated? Must there be evidence from the requesting state? And if not, why not? If there is evidence from the requesting state, what weight is to be given to it? And what if it's challenged? The reason why we say it leads to capricious results is what happens if there are too many failed extraditions to a particular jurisdiction. Would corrective action on the part of the district judge then be necessary because it was causing damage in the instant case? So, again, the predictability and certainty in this area that is so necessary would be undermined. The third point that we make on the basis of our challenges to the appellant's argument is that we submit that the appellant's reliance on the expulsion cases is of no assistance because in those cases the public interest is wholly different. Extradition, put simply, extradition is not expulsion in terms of immigration control. It is far more closely associated or analogous to the implementation of domestic criminal laws than to deportation. And crucially, it involves a request from an overseas authority for the return of a defendant either to face trial or to serve a sentence already imposed following a trial. The immigration cases, on the other hand, are concerned solely with the expelling state's ability to banish an individual after he has served punishment for the offence. They might be characterised as rehabilitation cases rather than criminal justice cases. On this aspect, we say that the Bull-Teef criteria cannot be transposed to the extradition context, and if they were, it would undermine the workings of extradition. Just to take one example, one of the criteria is whether the spouse of the person to be expelled knew of the crime at the time it was committed. Why should that have anything to do with an extradition request, any more than it would have anything to do with a domestic decision to prosecute? When you take a domestic decision to prosecute, you don't say, did the defendant's wife know about it? Be a pretty extraordinary prosecutor who took that sort of consideration into account, and nor should he, in the extradition context.
Can you remind me where we find these criteria?
Lord, I'm going to come on to them, but the Bull-Teef criteria, my Lord, are...
sorry, don't take me out.
I'm sorry,
take yourself out of order. If we're coming back to it, I'm quite confused.
I was going to go through them at all.
Yes, well, let's leave it until then to save time.
Lord.
Sorry.
Thank you. Lord, the fourth point in relation to our challenge to the appellant's arguments is that we submit that if the appellant's argument is accepted, it would inject radical uncertainty into extradition proceedings. And there is something we would submit fundamentally wrong in requiring a district judge to embark on a proportionality exercise without any guidance whatsoever, but in the knowledge that it will only lead to discharge in rare cases. We submit that that is futile and, for the reasons already given, a confidence trick on the public. A legal representative would not be in a position to advise his client. Save to say, you have an Article 8 argument, there are no guiding principles, we can run the argument and see how it goes. Well, we submit that that cannot be right. The fifth point that we make as a fundamental objection to the appellant's case is that the appellant's argument, if accepted, would have the result that proceedings which should be conducted speedily and without complexity would become unmanageably fixated on issues raised by Article 8.
Just say that again. Would become what?
They would become unmanageably fixated on issues raised by Article 8. And what is being done, my lords, in this case, take the intervener's argument as an example. Article 8 is being used as the mechanism to smuggle in Article 6 arguments that you can't otherwise raise, Article 5 arguments that you can't otherwise raise, and strength of case arguments that you can't otherwise raise because Parliament says that you don't have to have a prima facie case. And we would submit that the appellant's arguments, if accepted, would confound the purpose of extradition proceedings rather than serving the interests of justice. And the merits of the approach adopted by the High Court is that it provides clarity, certainty, and predictability of outcome, values which are vital in proceedings designed to assist in the fight against serious crime and to facilitate cooperation between states. May I deal with just one or two points from the oral submissions yesterday and today. The first point is the reciprocity point, the treaty the appellant submits does not impose reciprocal obligations. We submit that it does. We say there's a reciprocal obligation to extradite contained within the treaty. It's a different matter to say that there is not a precise symmetry in the documents required for outgoing requests on the one hand and incoming requests on the other. But that does not detract from the obligation to extradite imposed both on the United States, in this case, taking it as an example, and on the United Kingdom, imposed by the treaty. The second point, in response to the intervener's submissions, so far as domestic criminal prosecutions are concerned, we submit there is no right to have all the matters raised by the interveners considered when a domestic prosecution is being considered. It would place an impossible burden on the state authorities. Of course, that's not the only reason why there's no right. It's because once the decision has been made that there is a realistic prospect of conviction in a particular case, and the public interest lies in favour of a decision to prosecute, then the Article 8 considerations collapse into that particular analysis.
I mean, some of the Article 8 considerations would come in certain cases in deciding whether, for example, to prosecute an 80-year-old man for an offence 30 years before or something like that.
Yes, or whether Ernest Saunders should be prosecuted because he's got Alzheimer's.
Yes.
But that's for the criminal court to decide in due course. But what you can't do, my lord, and what's been made quite clear by the domestic authorities on challenging decisions to prosecute is that it's got to be dealt with within the criminal court's process, and the threshold for challenge is extremely high. And when it comes to Article 8 in the criminal justice system, or the criminal proceedings, of course, sentencing is based on proportionality. It's a fundamental principle of English sentencing practice. Part of the problem in the Wellington case was that the sentence of life imprisonment without parole that would be imposed in the state of Missouri in the United States was a mechanical exercise where it was for the governor to decide whether the particular defendant should be released. But, my lord, we submit that Article 8 would have no impact on decision-making in relation to decisions to prosecute in England and Wales.
But I thought my lord's illustration was actually at the point of prosecution. When you're deciding, you've decided that there's a realistic prospect. You go on to decide, is it in the public interest to prosecute? I mean, do you totally shut your mind at that point to the fact that he's 80 and...
No, my lord, I'm sorry, my lord, if I gave that impression, but my lord, no, but it collapses into the test for prosecution, because the test for prosecution is whether there's, first of all, there's a realistic prospect of conviction, and secondly, whether it's in the public interest. And when it's in the public interest, when you're considering public interest matters, you consider the personal situation of the defendant so far as you know it.
Quite.
But it's not about the Crown Prosecution Service telephoning a defendant to say, we're thinking of prosecuting you. Do you want to send us the medical reports for us to take them into account at this stage and tell us how you're placed as an individual, because we don't want to breach your Article 8 rights. I mean, it would be a hopeless system, and no one could seriously contend that that should be adopted. But the criminal justice process will itself accommodate Article 8 arguments along the way, because it may be, for example, that you would stay proceedings on the basis that a defendant could not have a fair trial because he was ill and old and frail, or it may be that the trial process would have to be modified to take those matters into account. But certainly you don't have the sort of factual assessment that has been contended for in this case. And the third point in relation to the submissions that have been made, any criticisms of the district judge and the structure of his reasons, we say would be misplaced. He did give reasons for his decision. He set out the basis of his decision, and it could not seriously be contended that the decision was vitiated by reason of the failure to identify whether it was family life or private life that was engaged by Article 8. Lords, may I go on to make a number of additional points, trying to pick up the argument as I go along. But Lord, for the proposition that extradition is an area where clarity and certainty are particularly important, see my Lord Brown in the Gomes case, Volume 1, Divider 11, at page 1047 at letter E, and I don't propose to turn it up at the moment, my Lord. If I may just give your Lordships the reference.
Could you repeat the reference?
I'm sorry, my Lord. Yes, it's Volume 1, Divider 11,
Thank you.
at page 1047 at letter E, where the House of Lords made it clear that this is an area where clarity and certainty are particularly important, and we respectfully agree and rely on that observation. In relation to the importance of international cooperation as an aspect of extradition which sets it apart from both domestic criminal proceedings and from immigration control, it is relevant, we would submit, to note that since the Extradition Act 1870, which marked the beginning of modern extradition law, the trend has been to ensure that extradition takes place with the least possible complexity and delay.
Not very successfully.
Well, my Lord, this is another point that we would submit, my Lords, because we would submit that we are of course concerned with Part 2 of the Act and Section 87, but the analogue to Section 87 in Part 1 of the Act is Section 21. Now, we submit that the Act must work the same both under Part 1 and under Part 2. You couldn't have an Article 8 exercise, balancing exercise, that's different under Part 1 and from the way it operates under Part 2. Now, given that the 2003 Act was designed to provide a simpler, quicker and more effective procedure for the extradition of individuals from the United Kingdom to friendly states, we submit that it would be unfortunate, to say the least, if we were to return to the pointless technicality and inexcusable delay that has so frequently characterised extradition from this jurisdiction, particularly when the point is made about prima facie case. It was the fact that the United Kingdom always required a prima facie case, even from civilian law systems where the concept was unknown, that created so much difficulty in extradition until it was discarded when the United Kingdom ratified the European Convention on Extradition and moved to a conduct-based test based on the provision of information by the requesting state rather than an evidence-based test requiring the establishment of a prima facie case. And given that there is a need for simplicity and speed, we submit that when it comes to Article 8, there must be a starting point. And for the reasons that we've given, the starting point is that there is the heavy weight in the scales in favour of giving effect to extradition arrangements. And that, in fact, appears to be the approach of the Conseil d'État in France.
You're really saying, start by saying you need an exceptional case to outweigh the burden in the scales, aren't you? I mean, it's all semantics, but you're basically challenging Mr. Sumption's thesis that you don't have an exceptionality type test.
Well, but Lord, it does come,
Yes.
there is a lot of semantics in this, because rather like in the immigration cases, where one of the things the Court of Appeal said after the decision of the House of Lords in Huang is, well, it isn't going to make any difference in the vast majority of cases, because people were, in fact, coming to the right result. But Lord, there is a juridical difference in as much as it is conducting a balancing test, but it's ascribing weight to the relative interests. It's not saying we don't conduct the balancing test unless you produce something that engages the scales to be weighed one way or the other. But when you're conducting the balancing test, you have to approach it on the basis that the public interest in giving effect to extradition is so weighty, then there will factually have to be something very striking and unusual to counteract that balance.
Well, if you're right in saying that it's always constant and always heavy, then the point of inquiry does shift to the other side, doesn't it? I mean, you're presented with that as a given. And the question is always, given that element, whether you're going to tip the scales the other way.
Yes.
That's the thrust of your argument, really, isn't it?
Yes.
I mean, you're saying, well, perhaps you should call a spade after all, but that's really what it is.
Well, my Lord, I know the court has our argument. For our part, on analysis, if you look at what Lord Justice Law says in Birmingham, we would submit that although he talks about exceptionality, on one reading, it's a perfectly proper approach, because he's really giving full force and effect to extradition. And it is interesting that even as early as January this year in France, the Conseil d'État is adopting precisely that same approach, because it's saying, in principle, extradition will always satisfy the requirements of Article 8.
I wonder if starting point is quite the right word. The starting point could be that, yes, Article 8 is engaged, but on your analysis, what you're saying is that in the proportionality exercise, the weight to be given to the public interest is enormous and constant.
Yes. But Lady, I was saying it on the assumption that Article 8 is engaged.
Yes.
Because there may be some extradition cases where Article 8 wouldn't be engaged. For example, the person who shoots someone in the United States jumps on a plane and he's arrested at Heathrow Airport.
Yeah.
No question of Article 8 rights. And the Rueth and Jaso case, although they'd been here for some time, they were in fact plotting a bomb attack in Santander. And they were rather cagey about what their private life and family life might be here, perhaps for their own reasons, but in any event. But in this type of case, where you've got a person operating in this jurisdiction, reaching into an overseas jurisdiction to commit an offence, private life and family life may well be engaged, certainly family life. But
Could I ask you another question about that, in case I forget, which I so frequently do? Are you at any stage going to discuss precisely how the relevance of the wife's article, Article 8 rights come in here? Is it something that is causing me some concern? about whether they should not. Can I just park that question with you and maybe you'll come back?
Well, my lady, I was going to say something about this because, consistent with my theme that these proceedings have to be conducted speedily and expeditiously, if you do go down the route of, well, you've got to take everyone's Article 8 rights into account, take a case such as Bieku Betts, where the House of Lords, I think it was that case, or it was one of them, said you may have to have separate representation for the children or the wife. Now, that raises the spectre in extradition proceedings of families having separate representation. Well, we would submit that that would be extraordinary in extradition proceedings, in the same way it would be extraordinary in domestic criminal prosecutions. Separate representation by those impacted by a decision to prosecute. And even if we're wrong about that, it doesn't alter the weight that we say should be attached to the interest in extradition. And may I just pick up another point in relation to this, because one of the matters that we say is a matter of real concern, and it's a point that we would make in response to an observation made by Lord Lord Mance this morning about, well, perhaps different considerations apply in rape as opposed to perverting the course of public justice. Well, we submit no different considerations apply, because if you're going to go down that route, you create a discriminatory system of extradition. And in fact, there's a danger of that in this case.
Well, I mean, you are going further, actually, than Lord Justice Laws, because he said the gravity of the particular extradition crime may affect the weight to be attached to these factors.
Well, my Lord, I'm perfectly content to accept that it may, if you've got a more serious crime, that may. But what
you can't have a one-way scale.
Well, why not go further than Lord Justice Laws? I mean,
I
test your argument.
Yes. What we are seeking to do.
What you say doesn't it fly in the face of one's natural instinct, insofar as a human rights point is conceivable? Surely you would naturally look, in addition to the general substratum of public interest which you've identified, at the particular extradition crime. Now, I take your point that all extradition crimes must have a certain seriousness, but some are more serious than others.
Well, in those circumstances, my Lord, you have one extradition law for the blue-collar criminal, and you have another extradition law for Tony Soprano. Because if you're the mafia don who nurtures his family life and sends his children to respectable universities and keeps himself away from the offending and its white-collar crime, then you say, well, you've got a very good family life argument. But this person who committed the rape, who is feckless in his personal life and does not have the family ties that Tony Soprano has, you are extradited. Now, we submit it doesn't work like that. And the reason it doesn't work like that is because it's a constant in every case. And
what did we think we were doing then in remitting this case for a further consideration of this?
Well, my Lord, I argued against that. Well, my Lord,
that's an opportunity for you.
Well, my Lord,
You've got 9 of us now.
Well, my Lord, this is now an opportunity for this court to speak authoritatively to assist legal practitioners and judges, and also to engage in a future dialogue with the Strasbourg court as to the way that Article 8 may impact in extradition proceedings.
Well, something on which Strasbourg has been wholly silent thus far.
And, Lord, but it won't be, because because it will have a golden opportunity if this appeal is dismissed, because I've no doubt what will happen. What's happening at the moment is that there's pretty much a freeze on extradition traffic at the moment. There are 7 cases in Strasbourg awaiting decision, and with another case on the way there, and possibly this case if the appeal is
What,
decided.
all Article 8?
Mainly Article 3.
No, that's what I thought. I mean,
yes.
Wellington and that lot are all Article 3.
Yeah, they're Article 3.
What's the state of play on Article 8?
None involving Article 8,
No.
although Mr. McKinnon is threatening to
yes.
go to Strasbourg in relation to Article 8. But Lord, what we say is that the care must be taken to separate out the commonplace consequences of an order for extradition, which will never in any case amount either to oppression or a disproportionate response.
So, just so I'm clear, I mean, when you said the blue-collar chap on one side, Tony Soprano on the other, and you said it doesn't work that way. In other words, Tony Soprano can't get a leg up from Article 8 because, I mean, so how does Article 8 apply, or does it not apply? How do we deal with it? If that's, but what are you saying about it in the case of Tony Soprano?
Well, my lord, what I'm saying is that if there are, it's accepted that there may be, in certain cases, the striking and unusual facts, or that will give you the tenable argument in relation to proportionality, but otherwise, no. Otherwise, by adopting our starting point in relation to weight, then you eradicate that sort of discriminatory assessment between those who don't have a family life to speak of and those that do.
I mean, I would find it very helpful if you could just instance a situation in which you would recognise that you could have an Article 8 defence.
Well, my lord, the examples would be the type of examples that the House of Lords identified in the Gomes case, where there was a particular case. I think it's called Davis, where the putative extraditee was the sole carer for a young child who was seriously unwell, and that was under the 1989 legislation. I think it's referred to in the Gomes case.
I think we weren't sure it was right.
Well, this is part of the reason for asking you about the relevance of the wife's family life and private life. Because the reason why that might be a striking and unusual case is not so much for the putative extraditee, but for the sake of the child.
Yes. Yeah.
Where do we discuss that case?
If I just Gomes is in Volume 1, Divider 11.
It's just a reference. But paragraph 29 is a mention.
And, my lord, if your lordship goes to page 1048
No, it's not the same.
of the report, at letter F,
Yes, it is. That's really
it's just below letter F at 1048.
Yeah.
The decision of the Divisional Court, Lord Justice Hobhouse and Miss Justice Moses in Davis, discharging a defendant who become unfit to plead, notwithstanding, I think that was also a case in which he cared for a child. I think that's right, but that's from memory. I know it was one of those. But there is a similar sort of, there is a similar case where if we go to volume 2, the Warren case, the Warren case is in volume 2 at divider 24, and this was...
Is this Brenda's case? Yes, I remember.
This involved an extradition request submitted by the United States, and if I may just summarise the facts, he was age 56, married with 3 children, one of whom had suffered brain damage at birth, and the defendant was himself unwell, suffering from depression, and 4 psychiatrists expressed the view he was unfit to plead. But the statements of principle really, in my Lady Justice Hale's judgment at paragraph 40.
1-4?
40.
4-0.
Paragraph 40, my lord.
Yeah.
This was a case where the challenge to the extradition was rejected, and my lady said that because of the importance of the decision to the claimant and his family, I only wish to emphasise my main reasons for doing so. The object of extradition is to return a person who is properly accused or has been convicted of an extradition crime in a foreign country to face trial or to serve his sentence there. This includes the determination of whether he's fit to be tried, an issue under which the criminal justice systems of both this country and New York is to be decided by the court, not by the members of the executive or the medical profession. The extradition process is only available for return of friendly foreign states with whom this country has entered into multi or bilateral treaty obligation involving mutually agreed and reciprocal arrangements. Counsel, on behalf of the claimant, accepts there is a strong public interest in our respecting such treaty obligations. Such international cooperation is all the more important in modern times when cross-border problems are becoming ever more common and the need to provide international solutions for them is ever clearer. Now, that was a case where, of course, there was 3 children, one of whom had suffered brain damage at birth. The defendant was himself unwell, suffering from depression. 4 psychiatrists say he's unfit to plead, but the court says the challenge to extradition must fail. So that's...
What we just noticed a reference to Article 8 in the next paragraph.
Yes.
The challenge wasn't...
It was to the Secretary of State, lady, and I accept that. And it was to... And it was at a time when the court was looking at the Secretary of State's decision rather than undertaking the proportionality exercise itself. But we would submit that that's a case where the challenge failed, and it's an illustration of how extreme the facts would have to be for a challenge to succeed.
I'm interested in the interplay of this extradition situation and the Article 5 situation, because Article 5 is a black and white situation which entitles deprivation of liberty in specific circumstances, including circumstances which are dealing with crime.
Yes.
Both applying to the grant of bail and to locking people up by way of sentence. And it's a novel proposition that, well, though Article 5 says you can do it, you've still got to do a balancing exercise because Article 8 rights are in play.
Well, Lord, we would submit that once you've complied with Article 5, Article 8's got nothing to say about it, because Article 5 has itself within it in accordance with law and not arbitrary. And of course, if a sentence were wholly disproportionate, you might have a tenable Article 5 problem. But that's why we submit in this case the intervener's arguments try to inject into the Article 8 argument what they can't get from Article 5, Article 6, or any other protection, or Article 3, or any protection that you have within the Convention. And I'll come on to deal with those in due course, if I may. But, my Lord, one of the submissions I was going to make, Lord, is that the Extradition Act provides an elaborate scheme of protection. And it is interesting that when you work through the Act, human rights considerations come at the end, when you've decided no extraneous considerations, not oppressive, extradition crime, conditions made out. And we would submit that by the time you get to consider human rights, you've excluded oppression, you've excluded injustice, you've excluded any medical or physical or mental condition, and you've also found that the conduct amounts to an extradition offence, and we submit that there's very little room left there for Article 8 to provide you with a remedy.
That's what I was going to ask you, because Article 8 comes in under Section 87 in relation to persons who've been convicted just as much as in relation to persons like the present who are accused. So what is Article 8 addressing in the Section 85 context?
Well,
I mean, is it addressing cases where the conviction's unfair?
No.
Was that covered in some other way?
No. But Lord,
Where's the Act?
If you get, Lord, the Act is in Volume 4 behind Divider 61. And, but Lord, may I just say something in relation to the conviction, why it cannot be addressing the conviction point, the fairness of the conviction. The way the Act operates in a conviction case is once the district judge has worked through the bars to extradition, if it's a conviction case, the district judge also has to look at Section 85, which bears the side note case where a person has been convicted. And there are two routes to extradition. The first is where the person has been convicted in his presence. So that's the first thing, because you may be convicted in Italy, for example, in your absence. But then the question arises, if you were convicted in your presence, you simply go through to Section 87. So the fairness of the proceedings is not in question because you participated in them. But if you were not convicted in your presence, the judge has to go to 85.3, and you've got to decide whether the person deliberately absented himself from his trial. And if he decides the question in subsection 3 in the affirmative, you then go straight to human rights because you've waived your rights in relation to the trial. However, if you were not convicted in your presence but you didn't deliberately absent yourself from the trial, the judge has got to decide whether you would be entitled to a retrial or on appeal to a review amounting for a retrial. So, for example, in France, you don't have to be present. The courts there convict you, but they say if you return, you have an automatic right to review, even if it's by the Court of Cassation, amounting to a retrial. And then if the judge decides that you would have a retrial, you proceed under Section 86, and that's where what the form of the retrial would take. But if you're not entitled to a retrial with the safeguards, you must be discharged. So there are the protections in relation to a conviction case. Now, my Lord, one of the arguments I made in the Gomes case, which I might say was rejected, was that Section 87 in an Article 6 case should not add anything to an injustice case. So in other words, my submission was, if it's not oppressive for the purposes of, if it's not a flagrant denial for the purposes of Article 6, it can't be oppressive for the purposes of Section 82. Now that was rejected, and I would invite the court without trying to reopen that, to consider whether, once you've gone through all these stages within the legislation, the protections which appear from Section 80, the rule against double jeopardy, Section 81, extraneous considerations, you're not being prosecuted on account of your race, religion, nationality, gender, sexual orientation or political opinions. Section 82, passage of time, it's not unjust or oppressive to extradite. Section 83 is a specific hostage-taking bar, which doesn't really add anything, but that's an example. Section 83 is an example of the principle of prosecute or extradite. If you don't extradite, you must prosecute. That's where you're charged with a hostage-taking offence, but you won't have access to your consular officials, and that's a bar to extradition. But under the relevant convention, if we don't extradite, we're obliged to prosecute. And then Section 84 is where a person has not been convicted. May I just, while looking at this, just show your Lordships Section 84(7), because Section 84, subsection 1 is the judge is required to proceed under this section. He must decide whether there's evidence which will be sufficient to make a case requiring an answer by the person. This is the prima facie case. But that's disapplied by reason of subsection 7 if a state is designated by the Secretary of State. And the designated state, if your Lordship just go on 2 dividers to divider 63, just keeping a finger in section 84, there's the relevant order, and your Lordships will see, and my lady will see at page 4 of the order, the territories paragraph 3 on page 4, subparagraph 1, the territories set out in paragraph 2 are hereby designated for the purposes of section 71(4). If I may, if 71(4) is the requirement that says there must be evidence justifying an arrest, sufficient evidence that would justify an arrest domestically, and it may be information rather than evidence. That's section 71(4). 73(5) is a provisional warrant where ordinarily you would have to have evidence justifying an arrest, but it may be information. 84(7) is the no need for the prima facie case in an accusation case, and 86(7) is no need for a prima facie case in a conviction case where the conviction was returned in the defendant's absence and the defendant will be entitled to a new trial. So that's the way it works, my Lord. I hope that's explained.
But let's just take a case where you hadn't been convicted yet, and you said whether it's a country where you have to show a prima facie case or not, this might be possible. You said this is going to be a kangaroo court. They are biased against me, and I know it's going to be fixed against me. If you could make out a case of that, that would be, in other words, that there would be a flagrant injustice in the country to which you were proposed to be extradited, that would be a human rights point under Section 87, wouldn't it?
Yes.
And, well, similarly, you could presumably do the same after conviction. You could say, I was convicted, I was there, but it was a kangaroo court, I was lucky enough to escape. I shouldn't be sent back now because of Article 6 considerations.
Yes.
You so could.
Yes. But Lord, I fully accept that yes. If you can get through the flagrant denial threshold, that you've got that. And
so there is some content to the human rights and provisions in both situations.
There's some content, but it's interesting that there is, of course, the examples that your Lordship postulates are pure foreign cases where there is the affront to humanitarian standards or values. What we submit you can't do is say, well, we can't get this into a foreign case flagrant denial category for the purposes of Article 6, but we can defeat extradition by showing that although there may be some unfairness, that's brought in now under an Article 8 point.
Before the Human Rights Act, Lord Mance's points would have been dealt with by the Home Secretary's discretion?
Yes.
And
yes.
Is there anything in the Act now, apart from the Section 87 or the Human Rights section, which would enable extradition to be refused for those sort of grounds?
My Lord, a hesitant and cautious no, because in the McKinnon case, I think it was McKinnon number 1 in the High Court, the High Court accepted that for the purposes of Part 2, where the Secretary of State does have some part to play on specialty considerations, death penalty, and earlier extradition, that there would still be the possibility of a challenge to the Secretary of State's order to extradite on the basis of human rights considerations arising at the conclusion of the court process. Now that is being deployed yet again in that case, but there is now recognised to be a residual human rights discretion for post-appeal events. Under Part 1 of the Act, where there is no Secretary of State's discretion, the High Court has decided that any remedy for a person being extradited to a European Union state lies in the Taylor and Lawrence jurisdiction to reopen High Court appeal proceedings on the basis of exceptional new circumstances which have arisen since the appeal was dismissed. So there are protections, but what it means is that the framework decision that says that we are to extradite within 60 days or 90 days, 90 days at the outside to our European Union partners, is not being met in a good many cases from this jurisdiction. Lord, may I just deal with the Strasbourg decisions? It's not necessary to turn them up because your lordships have, and my lady, have been referred to them. But when your lordships look at Suring, which is volume 3, divided 51, may I simply invite the court's attention to paragraph 89, which, although your lordships were referred to the authority, I don't think any criticism at all. Paragraph 89, no reference is made to it, but of course it is the important paragraph in relation to the increasing interests of all nations that suspected offenders should be brought to justice, and it's also the safe haven point. So that's paragraph 89 of Suring.
I mean, do I remember right? Isn't that the one that was then commented on in Chahal? And Chahal's, or have I got the wrong paragraph?
Your lordship is absolutely right. I think it was paragraph 89, but it's also dealt with, my lords, in the House of Lords decision in Wellington, where the majority in Wellington said that the extradition context was vital when considering whether treatment went through the threshold of what was inhuman or degrading for the purposes of Article 3. And although Chahal and Saidi, the later cases of the Strasbourg Court, had commented on Suring, it had not undermined the essential principle in relation to the importance of the extradition context. And the decision in Wellington is in Volume 2, Divider 25, and the relevant statements of principle in the majority's reasoning, Lord Hoffman, paragraph 24, my Lady Baroness Hale, paragraphs 50, 51 and 52, which is also relevant on sentencing, because my lady said in paragraph 52 of Wellington that it's not part of our extradition process to comment on sentencing practices overseas. And Lord Carswell, paragraph 58. The Launder decision, your Lordships and my Lady have already been referred to. We simply note, as Lord Justice Laws noted with interest, that the Commission referred to exceptional circumstances in that case. And there are three other extradition cases in your Lordship's bundles. Two involved Article 8 argument. They're both Commission decisions, decisions of the Commission. Volume 3, Divider 39, is HG in Switzerland, a Turkish national of Kurdish origin living in Switzerland with his wife who was Turkish and with two children. This was, chronologically, this was after Suring, but before the Launder decision. And the Article 8 argument, which was found to be manifestly ill-founded, is to be found at pages 5 and 6 of the report, using the page numbers in the bottom right-hand corner. Paragraph 5, under Article 8 of the Convention, the applicant complains that his extradition would violate his respect for his family life, and the Commission noted that the applicant's wife and children reside in Switzerland. Therefore, it amounts to an interference with the applicant's right to respect for his family life. The Commission must therefore examine whether the interference was justified, and the Commission observed that it was based on the European Extradition Convention and therefore was in accordance with law. And at the bottom of the page, purpose of the applicant's extradition to Turkey was the execution of a prison sentence as a result of his conviction of kidnapping and rape. Furthermore, the applicant's wife and children are Turkish citizens, and the applicant has not sufficiently shown before the Commission that they could not, upon their return, adapt to the circumstances in Turkey. And then they articulate a margin of appreciation point and go on to say that it was justified as necessary in a democratic society, so manifestly ill-founded. And then the other decision is in the same volume at Divider 48, which is Reidel in Austria. This was a Russian national extradited from Austria to the Russian Federation, where she was suspected of murder. She married an Austrian citizen while she was in prison. She then escaped and they went on the run, and she said that if she were returned to the Russian Federation, she'd commit suicide. The Article 8 argument was found to be manifestly ill-founded. It's page 8 and 9 of the report. May I just, before looking at the Article 8 argument, on page 8, just look up the page, my Lord and my Lady, just to the second paragraph on page 8, because this was the Article 3 argument on where the applicant was claiming that her mental illness would act as a bar, and that the Commission noted that the circumstances in which her extradition was carried out did not go beyond the inevitable element of suffering or humiliation connected with the legitimate execution of the decision to extradite. So there is an acknowledgement of the element of suffering or humiliation, and then dropping down the page.
Well, I think we'll drop down the page at 250.
Oh, I'm sorry, my Lord, thank you.
please.